Welcome to the Ask the Expert Show with local celebrity hosts Steve O and Rene. Sit back each week while Steve O and Rene educate you with live in-studio experts, such as lawyers, doctors, home improvement, and financial experts in their field. Call in and have your questions answered each week at 888-565-1470. Now, here is Steve O and Rene with today's expert in their field.
Hey, good afternoon, and thanks for joining us for another Ask the Experts, where we bring you the top experts in the field of legal, health, and home improvement. I'm Steve O, along with my co-host Rene. We are here with two very familiar faces. We have attorney Robert Kay and attorney Michael Bender of Kay Bender Rimbaum with us today. We have missed you guys. I mean, you guys have been with us since the inception of our show, and they're here the first Monday of every month. If you live in a gated community, if you have an association, and you have a question today,
doesn't even have to be gated.
we're not even going to charge you.
Right?
No.
It doesn't have to be gated.
Just has to be mandatory.
Exactly.
It's free. Call us at 888-565-1470. That's 888-565-1470. And they would just love, if you've got a question, this is a great time to do it.
So tell everybody a little bit about your law firm.
Sure. You want to tell them, Robert?
Go for it.
All right.
Maybe you want me to tell them.
You can jump in anytime.
Yes.
Good to be
Michael's
back,
getting
guys.
tongue-tied.
Nice to see you guys again.
Good to see you too.
Happy 4th. Kay Bender Rimbaum, we are a community association law firm. Some firms you'll hear will do some community association work, some do more collections, but our practice is full service. It's what we do. About 95% of our practice is the representation of the HOA, condominium, cooperative. And as general counsel, we handle all matters soup to nuts, basically. So we assist our boards and management teams, if they're managed, with day-to-day operations, policies, procedures, attending meetings, assisting with meeting notices, things of that nature, elections issues, covenant issues, enforcing your documents, updating and amending your documents, creating contracts, reviewing contracts, negotiating contracts. You can tell it's a lot. It's basically these board members are actually they are volunteers, and God bless them for taking that role on. But they are sitting at the table overseeing businesses. Some of these businesses are very large, in fact. So whether it's big or small, though, they are board members of a corporation. And as general corporate counsel, we assist with all these matters. So that general day-to-day matters. We also have experienced litigation attorneys who assist with anything from contract challenges, contract breach of contract claims, construction defect-related matters, covenant enforcement matters, and anything in between. And then, of course, we do have attorneys and staff who do assist our clients when they do have issues with collections, delinquent owners, collecting assessments or special assessments or any other monetary obligations. And we have about 800 communities throughout Florida, going all the way from Ocean Reef through Indian River and beyond. Up north, we have an office in Palm Beach Gardens.
So you cover Palm Beach and Broward.
We cover Palm Beach, Broward, Dade. We go Collier. We go Indian River.
Martin, yes.
Martin, absolutely. Into Orlando. We even have some clients up further north than that. Our partner, Jeff Rembaum, who is out of the Palm Beach Gardens office, assists a lot of our clients up there. And we have our clients down Miami-Dade and all the way into Ocean Reef, down the Keys.
We have a caller. We have Nancy on the line with a question for our attorneys. Hi, Nancy.
Hi, how are you?
Great. Do you have a question for either Robert or Michael?
Or both.
Or both? Yes,
well,
exactly.
Whoever wants to field the question, I've been through a year through the ringer as everybody in my community with our prior management company and board, which was run like a little fiefdom, and it was terrible. I mean, I can't even tell you. And we finally, I can't talk too much about it, as I said, because it's in litigation. But what's your perspective on having a professional management company versus being self-managed? Because I'll tell you what, this last management company, I can't even tell you what a horror story it was.
Well, this is Robert, and thank you for your call. From a legal perspective, there isn't a lot of difference between professional management and being self-management. They're both legally appropriate and correct. it becomes more an issue of practicalities. It's unfortunate that you had a bad experience with a management company, but there are many high quality caliber management companies in this locale. So you unfortunately weren't with one of them, and that would be what's driven the experience you've had. Doing self-management is an option that can create additional problems because of the technical aspects and the time commitment that's required to run many communities. And if you've got volunteers doing it, it's a matter of how much time do they have and are able to devote, and sometimes it becomes overwhelming. There's also the aspect of the accounting side, which can be very technical as well. So you have to be sure that you're able to handle exactly what it is if you're going to go on the self-managed side.
Okay. I mean, I assume that most communities do have a management company, and we just had a bad experience with one. We have a new one now. It took us a year to get it sorted out, and it's just not me. It was everybody in the community was just fed up, and but the new one seems to be working. So far, so good. But I was just curious as to how many communities really self-manage to avoid this kind of problem.
Honestly, in our experience, it happens more in the smaller communities than those that are larger with a higher dollar budget that they're having to deal with.
Yeah, we have a really large community, so it's
self-managing a community. Sorry, Nancy. This is Michael. Self-managing a community, then, if you're a large community, as Robert was indicating, I think would be more of a challenge. Those communities that we've seen that are self-managed are smaller, and also, so they look at it more from a point of economics, as well as the ability to be able to handle the nature of managing a small community. But when you get in, if you're a larger community, then I think you're looking at either the management company, and it's good that you found a good one, because there are several that are very good down here in South Florida. And others will sometimes, I don't know how big your community is, but sometimes they'll just take on a permanent on-site manager who may not even be related to a management company, would just be an independent manager.
Okay. All right. Well, as I said, our poor community, we had terrible, terrible problems, which I could take up your entire radio show discussing, but I won't do that. But I was just curious because now we've got a new company, and I guess we'll have to just see how it goes.
Well, keep a very close watch, and it's important that you're able to disassociate yourself with a professional company in your contract. You want to be sure that the terms that they offer allow you to terminate it without having to give very long notice or have a financial penalty.
Okay. All right. Well, thank you so much for your time. Nancy. I really appreciate it.
We're here the first Monday of the month for the whole hour, 4 to 5.
Thanks, Nancy.
Right.
Hey, we got another caller. She's been waiting. Let's go to Brenda. Hi, Brenda.
Hi, Brenda.
Hi there.
How are you?
I'm a realtor, and I'm trying.
Don't apologize.
I'm not. I have a buyer that we're ready to close on a condo, and we have had all kinds of bad luck trying to get documents from the association. Number one, there's no phone number. Number two, there's just a P.O. box. I've asked how many times, I can't remember, for financials, and he says, they'll get them at closing. And I've given them the page out of the condo rider that says that they have 3 days to look these over, and it just does no good. I can't get financials if my life was depending on it. What can I do?
Well, are you I know you're the realtor, but are you an owner of a unit there as well?
No, I'm not.
Okay, and you are the seller involved in this transaction. It's an individual person who owns a unit there?
Yes, and he says in the 10 years he's owned it, he's never got financials.
Well, this is tied into the prior caller and not having professional management, and it sounds like they're doing it themselves.
Correct.
Right. The law does provide that an owner is entitled to access to financials, obviously, as well as a set of the governing be able to get copies of the governing documents. It is the seller's responsibility, as you know, to provide these to the prospective purchaser. And in this case, the seller does have the ability to get these documents. So if they have not done so already, I'd recommend they send a letter by certified mail to the association's mailing address, office, or whomever, and maybe copy each board member, requesting access to inspect these records and or a copy of these records, and that puts the association on a statutory time frame to provide these documents. And if they fail to do so, then there's the ability to contact the state and address it through the state, either through an investigation and or arbitration.
Okay, the owner is out of town, so out of state, so like he can't come and look at the.
Well, the owner's representative can also go on his or her behalf.
Right, that letter that can be written by that he can authorize you, for example, to be the party to go in and inspect and get copies of these documents.
Well, part of your problem may be that they just don't have a lot of the documents that you need. And in that instance, you may find yourself needing to make a complaint with the Division of Condominium, which has an office in Fort Lauderdale, which is an administrative agency, part of the Department of Business and Professional Regulation in Florida. And they will contact the association and do an investigation as to certain things, such as the failure to provide financial information. And that might nudge them into doing something a little quicker for you.
I will see if I can get the owner to write a letter, and if that doesn't get us anywhere, then we'll go the other route. And I thank you so much for your.
Well, the last suggestion is your owner may need some assistance of a licensed attorney here in Florida to help shake that thing loose.
And if so, I know who to recommend.
Perfect. Well, thanks for calling in. We have another caller. We have Bruce on the line. Hey, Bruce.
Hi, how are you today?
Great. Do you have a question for our attorneys?
I do. Hi, Mr. Attorney.
Hi, Bruce.
You got two misters.
Property in Boca, and we painted the driveway. The rest of the community has just natural stone for the driveway. They're pavers, and we painted it. And now the board has contacted me via letter saying you cannot have a driveway painted. It has to look uniform. You need to sandblast, pressure clean, whatever you have to do to remove the paint. So what do we do?
Well, your issue that you've raised is what we call document specific. You have a set of documents for your community declaration of covenants that outline various responsibilities, entitlements, liabilities on both the association and the individual property owners. We'd have to first see whether or not what they're saying is correct, that there's documentary support for the association's position. If the documents are not clear on that, or there is no appropriate documentation, then they could be wrong in the position they're taking, but it's hard to answer that without seeing the documents. So you may want to consult with an individual who can address your documents for you to make sure whether you have a case or not to defend yourself. If your documents support the association, then the best course of action you could take would be do what they say quickly, as opposed to getting a lawsuit filed against you, which could require you to pay their legal fees.
Okay, so if it is in the documents, which the president I spoke to is saying it is, so then we would have to hire a sandblast company to remedy the painting of the driveway, I guess.
Very possibly. It may not be a sandblasting company. It may just be a paving company that will replace it or do something different to be more in compliance with the restrictions.
Okay. Well, thank you kindly for
thank you for your call.
My question. Thank you.
Bruce, before you hang up, just one last thing. If in fact you are going to be taking remedial measures, suggest or recommend that you get a proposal for those remedial measures, present them to the board or the architectural review committee, if that's who you got to present to confirm prior to you spending the money to do the remedial work that it is what will bring you in compliance.
Good point.
Perfect. I like that suggestion. Thank you, sir.
You're welcome.
Okay, have a good day. Love your show. Thank you.
Thanks, Bruce. Wow, we can't even get to the show yet.
Oh, this is the show.
Yes, this is the show. That's right.
We're at 888-565-1470. We have two of the top attorneys. We have the top law firm. We can say that.
Yes, we can.
We can say that.
And you should.
So what's going on in Tallahassee? As to
First going out of town.
Currently not a whole lot.
A lot. Summer break now that they just finished their special session.
It was an interesting session in Tallahassee this year because they stopped short before several of the bills that were pending were considered, and therefore they did not pass. So there was only a smaller number of bills that were passed this year.
why is that a good thing?
Because the bills that were pending, which appeared to be gaining favor, in particular, there was one bill regarding estoppels, which our firm and many law firms, of community association law firms and management companies and community association leaders were opposed to, ended up dying on the House floor because it never got a chance to be voted upon before the House ended their session. So at least for this year, that bill did not get passed, did not to go up to the governor for consideration. So that was why it was good that it
Can't be
ended
brought
early.
up again until next year?
Well, next year, yes.
Well, and next year, in this case, is January because their session starts in January as opposed to the normal
Something
March
new and
session.
experimental.
So what new bills did pass, though?
Well, there were several things that were adopted this year. The thing that I consider most notable is an electronic voting procedure for the elections, or any voting that associations have, has been approved for all three, the condominiums, homeowner association, and cooperatives. It remains to be seen whether it's going to be able to be implemented right away, because there are a lot of requirements that associations have to meet in order to qualify to allow for electronic voting. But
I would think that's better than paper ballots.
well, it has pluses and minuses, but security is a very high important issue. Making sure that you have one vote for one unit owner, that you can identify the owner but maintain the secrecy of the vote so that you don't know who they voted for. There are a lot of technical issues that have to be resolved in order to implement the process. Communicating through electronic means is something that had previously been required to be in the governing documents, but a change this year took that out. So now associations are going to be able to do their notices of meetings and important information by email to those owners that consent to receive it that way. They still have to send things through the mail, but they no longer have to amend their documents to have the power to do that.
Which is good.
So how does this impact the board members? I know we have to go to commercial break. So
Well, let's come back and talk
we'll
about
talk
that
about
after
that after
commercial.
We're going to go to break.
Okay,
When we come back, Kay Bender Rimbaum, our HOA and our association law firm.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we're back. Phone number here is 888-565-1470. If you have a question here for Attorney Bender or Attorney Kay, we are here to answer your questions. Call us now, 888-565-1470.
So let's get back to legislation. So we were talking about that. So how does this affect the board members for the new laws that have passed?
Well, the ones we just
We were
talked
just
about,
talking
like
about
electronic
the
voting and
exactly.
the notice requirements. It's well, I think in general, I think what's important is board members need to. I'll tie this into education. How do the new laws affect board members? It depends on which of the laws, which of the sections of the law we're talking about. House Bill 791, which is what Robert was just talking about, that's our community association bill that was passed. And there's about a dozen items that are in there, two of them being electronic voting and the ability to now notify people through electronic mail for notices. And so there are, those things will have, those things will require boards, or especially if you're self-managed, to be aware of these options. For instance, electronic voting. If you'd like to do electronic voting, part of the procedures require that there be a board resolution. And this board resolution has to contain certain specific requirements, which I'm not going to get into detail here, but it's important. And so you need your management team, as well as if you're a self-managed board, and even if you're not, if you're board members with management, you're going to want to be aware of what these policies and procedures are. This type of information is starting October 1st is when the state authorizes there be a legal update seminar for credit. We can give this type of education and do give this type of education between now and then. These laws all took effect for the most part July 1st.
Right, so these will be at your seminars that you hold?
Mm-hmm, some of them they'll be talked about. And then come October 1st, there's the official legal update seminar, which is a 2-hour program just talking about the new legislative changes that passed in 2015.
Okay, we have actually two more. Yes, we have two callers. So who do we have?
Mary's first.
Oh, we have Mary. Hi, Mary. Do you have a question for our attorneys? For Robin and Michael?
For the attorneys. Hello?
Hi, Mary.
Yes. I have a coworker, and she's like our EAP at work, and she helps everybody with their problems. And she's been like kind of really down lately because she's having a problem herself with her homeowners association. And she said she's getting like these threatening letters from them because she didn't pay her homeowners association fees. And they sent her letters that they were going to put liens on her house and then start foreclosure proceedings.
Well, this could happen, and it's important that she, as well as any owner within a homeowner association, make sure to keep current with their maintenance assessment responsibilities to the association. The onus and obligation is on the individual homeowner to make sure the payments are made timely and to the right place in the right amount. So there's no legal obligation for the association to send a monthly statement. There's an annual budget and a notification of what your annual assessments are going to be and the monthly installment, quarterly, whatever it is. If she's having financial difficulties, it's important for her to contact the board sooner rather than later.
Will they work with her?
And typically, boards will work with owners that will, be forthcoming and be reasonable, and don't offer $5 a month for 6 years. That's not a reasonable offer. But anyone who does not pay their association, everyone else has to pay for them because the association has a fixed amount of expenses, and it's split up among all the owners in their proportionate shares. So if one owner doesn't pay, everyone else has to make up the difference. And if it goes to more owners that don't pay, then it's that much more on everybody else.
Mm-hmm.
And there, unfortunately, is no defense to it.
Say again?
Yeah, she had some health issues.
Well, that's what she needs to bring to the board's attention, that while she intends to pay, she's having some personal issues that are going to require her to take more time than she otherwise would, and ask them for some understanding and to work with her, but she still needs to be making some payments toward what is due.
Okay.
Ignoring it could result in her losing her home, and that's not something she would want to do. The maintenance assessments in a homeowner association condominium have almost an equal standing to your mortgage, in that you could lose your home if you don't pay your maintenance, just like you could lose your home if you don't pay your mortgage. And it could happen faster for a lot less money.
Mm-hmm. Okay. She thought, well, maybe they were going to put a lien on her house, but she said, oh my gosh, they said they could do a foreclosure too. And she's been so distracted. She's been so upset. It's really a shame.
Well, it's very sad to hear that, but she does need to be proactive and reach out to them.
All right, I'll let her know. Thank you very much.
Thanks for calling,
Thank
Mary.
you.
We have Carrie.
Hey.
We have Carrie on the phone now. Hi, Carrie.
Hey there. Hi, guys. How are you?
Hi,
Doing
Carrie.
Great. Thanks for calling.
I live in a condominium, and our board is talking about doing some projects in the building, like remodeling the lobby area by the elevators, removing shuffleboard courts, putting in more grass, and a couple other projects as well. But so far, the board has been talking about these projects, but they haven't discussed asking the owners to vote on it. So should the owners be voting on these things?
Okay, and you mentioned it's a condominium, correct?
Yes.
Okay. What you're talking about is, when you're talking about projects in this condominium setting, you're talking about, are these projects something that are going to be considered necessary maintenance, or whether we're talking about the possibility of them being capital improvements or material alterations. And the reason that distinction is important is because if the projects would be considered necessary maintenance, for instance, they have to replace the cooling tower, or there's roof issues, or the elevator needs to be updated because it's not been functioning. Those items are going to be something that the board has the authority to do, not only the authority, but the obligation to do, whether or not, even if your documents required the board to get a vote. Say the board needed to spend $100,000 and you have language and levy a special assessment for that money, and you have language in your documents that says any special assessment needs membership approval. There's case law in Florida is clear that if it's a necessary maintenance related project, that's going to be something the board has the authority to do and to levy the special assessment for if necessary. Flip side, for instance, you said they want to, there was something about a shuffleboard court. Can you say what that was again?
Removal.
They're removing them.
Right, removing of a shuffleboard court. That would be something that would be looked at more as a material alteration of the property. And so there you'd have to look to the governing documents and ascertain from the documents themselves whether there is a requirement for a membership vote. Under 718.113 Florida statutes, they say unless your governing documents provide otherwise, then you need a vote of at least 75% of the membership to approve a material alteration to the common element.
And
So
if I could interject, that
Of
does
course.
presume that there is the requirement of a vote at all. The statute says, and just to enhance upon what Michael was saying, is that no material alteration except in the manner provided in your declaration. So first you have to look to your declaration to see if there's an owner vote requirement. If there is no owner vote requirement, or they're silent on it, then the statute says 75%. But sometimes it'll be tied to the dollar figure. Sometimes it just says no material alteration without a vote of X number of owners, so you have to check that. Some of the items you've identified could be considered more maintenance and not requiring an owner vote, and some of them sound like they would require an owner vote. So there may be the need to have further discussions with the board about that, but you'll also want to check into your documents as well.
I think they should keep the shuffleboard courts.
It's coming back.
I love shuffleboard.
Okay, Carrie?
Thanks very much, guys.
Thanks for calling in. Okay,
Bye.
so one topic that we have to discuss, we were discussing before we actually came on live on the air, is the assistance animals and service animals, because I know that there's so many people that are confused what the difference is. Can you explain to people what the difference is between the two?
Well, the primary difference between the service animal and the assistance animal and what we're talking about is service animal is a term that you find under the American with Disabilities Act, ADA, and which governs places of public accommodation. Whereas the assistance animal is a term that you find coined under the Fair Housing Act, and that is when you're talking about places of residential setting, which is primarily what we're talking about in our HOA condominium cooperative clients. These are places primarily these are private residential places, and so the difference with you're talking about a service animal. There are certain requirements under the ADA for service animals which don't apply to the assistance animal. For example, service animals are primarily limited to dogs. Also, they have to have a certain, they're required to be certified and have a certain level of training. Your most the best example and the easiest, the most common example of the service animal is the seeing eye dog.
Right.
Okay. The assistance animal, where the most common example that we see coming up is in the form of a companion or emotional support animal. These animals under fair housing laws are not limited strictly to dogs, nor do they require any specialized training or certification.
So it could be any type of animal, cat, bird, anything.
Within reason,
Yeah.
but primarily they are still dogs, but occasionally you see the cats or a bird or a potbelly pig. But true, but or these miniature horses, I think. But primarily the dogs. But the big difference, again, between the two is the assistance animal does not have any need for any specialized training or any certification whatsoever. In order for you to be entitled to have an assistance animal, you just need to be able to provide proper documentation from a qualified medical provider that supports your need for the assistance animal. So in a housing scenario, someone with a seeing eye dog, they're going to their disability is obvious and the need for the animal is obvious, so your discussion ends there. They're going to be granted a reasonable accommodation to any pet restriction or prohibition in the community. But with an assistance animal, an emotional support animal, a lot of times the disability is not obvious, or even if there is an obvious disability, it doesn't mean that it's the need for that particular animal is obvious. And that's where the board is entitled and should undertake a reasonable investigation to ascertain the validity of the request, and then once that information is provided, to grant the request. And I want to just emphasize that this is an area where all boards and management teams who are assisting boards should be seeking out association counsel, experienced association counsel, to assist on every step of the way. So a lot of times these are fact specific, and so it's a case-by-case approach, although what we've recommended to our clients is to create, and we help them create an application package. Basically an assistance animal package, so that if someone has a request for a support animal, they fill out, you give them this paperwork to fill out, and you have a uniform way of reviewing applications, and if all that information is completed, you're in a good position, look it over with counsel briefly, and then be able to provide that approval.
And can you deny it?
Well, I would never, let's put it this way, can you deny it?
Yes.
Can
Other
you deny
circumstances,
Can you deny it without exposure to risk? No, not in this scenario, in my opinion, in our experience. What I always tell, and as you know, we do a seminar in fair housing out of our Pompano office as well as our Palm Beach Gardens office.
So check the website.
The next fair housing seminar will be Tuesday, July 14th in Pompano Beach. And then there's also one Wednesday, July 22nd in Palm Beach Gardens. And you can go to kbrlegal.com to check the website for those seminar dates as well as times in future seminars. And we spend it in both classes in Pompano and Palm Beach. We spend an hour, solid hour, and probably more, just on the issue of addressing assistance animal type requests, assistance animal versus pet. And I always tell people, don't ever say no. Like, can you deny it? That should never be something you do. But you don't automatically say yes either. Undertake your due diligence, do your investigation. And if someone's not cooperating in a reasonable investigation, then rather than you saying no, it's them withdrawing their request. It's just a way of having you write things. But you need to use experienced counsel.
Wait, I have one more question before commercial.
One second. Before you said, you know what, there's associations out there, there's people listening to the show right now. I bet you know a phone number for a good legal representative.
Well, you can call us at 800
974
0680. 800 974 0680. Pompano directly is 954 928 0680. Palm Beach Gardens is 561 241 4462.
Okay.
If you missed that, we're going to give it again.
Absolutely. Let's go to commercial break, and we'll be back with more of Robert Kay and Michael Benta. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we're back. Love the show today. It's going really well.
We'll give out the phone number again.
If you want to call us, we've got two. I have to be careful how I say this. I don't want the state getting upset with me, but they are so good. Their law firm is K. Bender Rembaum. They cover basically all of Martin, Palm Beach County, Broward, Dade. So if you're in any of those areas,
Collier.
if you have a
Collier
question,
County. You're leaving out county.
how about St. Lucie?
There's so many
St.
counties.
Lucie
Port
as
St.
well.
Lucie.
Yes.
888-565-1470. 888-565-1470. And they are here with us the first Monday of each month, so it makes it really easy. Where are we going to go now?
We're going to talk about the seminars, and I know that you also have new courses for covenant enforcement
And elections, yes.
and elections. So you want to give dates for that?
Sure. And I will just a little backup. As you know, we've been doing seminars out of our offices in Palm Beach Gardens and Pompano Beach on board member certification for HOA, for homeowner board members, condominium board members, and out of Pompano, we've also been doing the cooperative board members, all of whom certification is required for all board members. And it's great education. I just urge all board members to take, if you can get to ours, great, we'd love to have you. At least get to one, though. And if you've been to one, come to ours anyway, because I think you always learn a little bit more, and then the people who are present always ask some questions which maybe you weren't thinking about. They're your fellow board members. We always ask at our classes, because we also go out and do a lot of seminars outside of the offices, these at conventions and trade shows, and even just when we do our annual seminars around the counties. What do we call that?
Town hall.
Our town
Town
hall.
halls.
Thank you. Our town hall trade show, town hall shows. We always ask, are there areas that you would like to learn more about? And two of the most common topics that came up were enforcing covenants, rules and regulations, and elections. And so it was our pleasure. What we did was we put together a 2-hour course, 1 hour concentrated on the enforcement of your covenants and your rules and regulations, and the other hour is on election issues in the HOA and the condominium setting. And so now what we do is we have this program, and it's out of Pompano right now. It's in the Pompano office right now. The next one will be on Tuesday, August 11th. Will be the next class. And what we're doing is we're doing it every other month. So it'll be Tuesday, August 11th, and then we'll give it again in October, and then again in December.
And what time does it run from?
It is 6:30 to 8:30 p.m. out of our Pompano office. And kbrlegal.com, our website.
You can register on
yes,
there?
In fact, we have a very nice new updated website, which I encourage everyone to go look at. We're very proud of it. And there are tabs to check out all our seminar dates. And you can reach us at 800-974-0680 if you have any questions.
Hey, I want to kind of lead us, and we have another call on the phone. It is so great how you guys give back to the community. I mean, this is all free. I mean, you forgot,
All
you didn't
free.
say that word. This is all free, so it's...
And light snacks provided.
And let me tell you something. I've seen their offices. You know, they do all these things. You've got to have a staff to cover this. It's like going into the Walmart parking lot. There's so many cars out there. So you are very well staffed, and you're happy for everything that you do. But I just want to thank you. You guys are just amazing how you give back to the community, and you do it for free.
It's our
That's nice
pleasure.
of you to say thank you.
Let's go to our next caller, Casey. Hi, Casey.
Hi there.
You have a question?
I'm calling basically to say, how can we make the board enforce the rules? We've got a new board elected in March, and we have problems, and somebody who was on the old board said to us, oh, well, the board can't do anything about enforcing this. Okay, I'm not on the board. I'm just a member. But we've got they're not approved renters, and they're not picking up after their dogs. They're creating disturbances. So what can I, as an owner, do? I mean, can my board enforce this, or was that person right that there's nothing they can do?
Well, thank you for the call. The board can and should be enforcing restrictions in your governing documents, but they may have found themselves in a position where they're legally precluded from doing so because they've not done so over an extended period of time. The Florida case law on the subject indicates after a certain period of time, the board is considered to have waived the ability to enforce the certain restrictions if they have not done so, which is a defense. It's not automatic and has to be raised by the owner that's being pursued, but it creates defenses for the owner of what they call waiver and what they call selective enforcement, that they're not uniformly enforcing the restrictions against everybody. But there is a method available to the board that they can use to, in essence, resurrect the restrictions and their ability to enforce it. This is known as republication. With republication, the board would identify whatever restrictions that they haven't been enforcing at a board meeting and indicate that they will start enforcing again on a specific date, and then send out notice to all the owners that as of a certain date, that they will start enforcing again on these restrictions. The catch to that is those violations that are in existence at the time have to be allowed to continue. They're called grandfathered in. So we suggest that you also incorporate in that notice a registration form so that individuals can register their existing violations. It's on record with the association. And anyone who doesn't register by the date that the board indicates, their violation is presumed to be new and subject to the enforcement by the board. But the board has to be willing to enforce. If your board is not willing to do that, you may need to change your board.
New elections.
Yeah, it sounds like a lot of work because it sounds like it's unit specific.
Well, it could be.
To a blanket thing.
It could be, but it also can be also a blanket thing. Like the thing with the picking up of after the dog is a new violation every time, so there's no grandfathering in of that. That's a little more difficult to enforce because you don't know whose it is, or you have to see it happening. But the unapproved renters is a situation that can snowball and become a real problem.
Okay, thank you.
Thanks for your
calling
call.
in.
I know, especially with renters out there, some of them just do not keep up their property like they should.
Well, a lot of owners don't.
So, I mean, what's their recourse? Does it have to be handled by the board?
Yes, the owners aren't in a position to take it up for themselves, although both the condominium and homeowner association statutes do authorize owners to bring legal action against other owners for issues of violation of the documents between themselves. And quite often you have neighbor against neighbor, and that's not an appropriate situation for the association to be involved in, but the owners themselves can deal with it through legal means.
And when the tenant is a problem, the board has to take it up with the owner. The owner is responsible for the anyone residing within their home or their unit, whether it's a guest or a tenant. So if there are issues with a tenant, then the board should be making the owner aware.
Because a lot of owners live out of state.
Or wherever. They're definitely not living on site if they have tenants. Or maybe they're living in another home in the community, you never know. But make the owner aware by noticing the owner of the violations and copying the tenants. Say, hey, this is when he's compliance. Ultimately, if they have to get counsel, and this goes back to what we talked about, the enforcing your covenants. You have to uniformly enforce your covenants against all owners on a consistent basis. And if you don't, and by sending notifications is your first step. Obviously, always, whether you're self-managed or you have a management company, always reaching out to the owners or the occupants of the home or the unit. Hey, you might not know this, but here's the rules, here's the violation, please get it complied with. If failing that, you have to get it to experienced legal counsel, and within a year's time. It's not enough for you to say, well, we notified them of it. You actually have to make sure that you get it in compliance. Because if you let these things go, if you send a few letters and then a year or two passes and those violations still exist, that's what Robert was talking about, where you now have the possibility where you try to go after them after a couple of years and they say, well, no, you've known about this, so now there's something called waiver. There's the defensive waiver that comes in, and that, if successful, now you have a position where I'm the violator, you've waived against me, so I get to keep my violation. Robert moves in tomorrow and you say, okay, well, I'm going right after Robert. We're not waiving against him, it's right away. And he says, that's right, but now you've selectively enforced against me, so he has another successful defense. So that's where he talked about republication. But it's important you get your law firm involved and take legal action, whether it's arbitration or court action, depending on what the issue is. Start with letters, and when it comes to us, we always try to get through letters. If we can avoid litigation, we will. But ultimately, the board has to authorize legal action through the courts if the violation is a year old, coming on a year, and they're not responding.
Can they evict the tenant?
If the governing documents of the association provide this appropriate language that allows the association to step in and act as the landlord, then they can take up an eviction action. But more often than not, you'll see the language will allow the will direct the association to file an action against the owner for injunctive relief, and that relief would be that the owner has to take action to bring the tenant in compliance or remove them.
Right.
The bottom line will be the same.
So we got to go. We're going to take our last break, and we come back. Maybe we can give out some of these other dates that are coming up over the next month. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
But the covenant enforcement.
And we are back for our final 15 minutes of our show. It's gone by so fast today.
Yes.
A lot of phone calls, a lot of people interested. You have some certification courses coming up.
We have lots of courses, all free courses coming up. We are offering this month, we have in the Palm Beach Gardens office on July 8th, the Homeowner Association Board Member class, and on July 15th, the Condominium Association Board Member Certification in Palm Beach Gardens. In Pompano on Tuesday, July 28th, will be the Condominium Association Board Member Certification. All of these, again, kbrlegal.com on the website. We will also be doing the Fair Housing Act class on July 14th in Pompano and July 22nd in Palm Beach Gardens. The class I mentioned earlier on covenant enforcement and elections that I said we had a lot of people asking about it. It's 1 hour program on covenant enforcement and a 1 hour program on HOA elections. They're back to back. For managers who are listening or interested, all of our classes, the certifications as well as the covenant enforcement, elections, and fair housing all offer free manager credits. So when you RSVP, we ask you to RSVP with your your CAM license number so we can make sure we can get everything properly taken care of. But that class on covenant enforcement talks in greater depth about what Robert and I just spoke about, with the need to be enforcing your documents uniformly and the process involved and the different options available and the republication if necessary. Some suggestions we make to amending your documents, which will allow the board to have better enforcement capabilities, and most importantly, because I know I've run into this a few times, it's not at the expense of the membership, but more importantly, to be able to address enforcement where you have a few individuals who are the main culprits in most communities, allowing the association to be able to go to those owners and say, we want you to reimburse us for the legal fees that you cost the community.
Well, not only we want you to, but you must.
Right. Yeah. So that's all part of the discussion at that covenant enforcement class, and then the elections and election issues in the HOA and the condominium. There's a multitude of different items and issues that come up there, and we've gotten, the attendance has been outstanding, and what I think is great about that is you have board members and managers who are attending, and unit owners on occasion too, who have different experiences, and they bring those experiences to the table, and so something you might not have even thought of when you came to the seminar. You get, oh, look, there's another topic that you hadn't thought of, or another string of questions, and so it's additional education that you might not have thought
We
of.
got to see that when they did their seminar with
Correct.
people holding up their hands. It's been reported in the newspaper there's been a lot of fraud that's been going on.
Mm-hmm.
And
Well, I don't know about a lot,
Okay.
but some has come to light
how about a few?
I have not done any fraud.
Okay.
that we know of.
So how can associations prevent different types of fraud?
Well, it's hard to do when there's somebody in a position of being able to do that without controls. So
Checks and balances.
it's important that the board, as well as the owners, be involved in the entire process of operating the association, keep their eyes on the books and records of the association. Certainly you don't want third parties signing on your checks. That should never happen. It should only be designated individuals from the board and officers of the association. You don't want your manager to be signing checks or putting them in a position where they could do things like that.
You want to see those financial records that you're entitled to see each month. I like that a prior caller said they hadn't seen records in years. So that's, if no one's gotten financial records in 10 years, that's a community that's ripe for fraud.
Every association is required to provide an annual financial report.
And who receives those reports? Do the actual owners receive those reports as well?
The owners receive them, or they may get a letter saying they're available. They just have to ask for them.
At no charge.
Right.
Okay, give everybody your website address and your phone number again.
KBRlegal, legal.com is the website. And like I said, it's newly updated, lots of great information. Legal Morsel tab and Rembaum Roundup tab have great articles. One of them, Robert mentioned the changes in legislation we put up there last week. Another one that's going to be going up, if not today, will go up, I think, tomorrow on about the Marketable Record Title Act. And this, if you're an HOA board member or even an owner or certainly someone who manages an HOA, you want to be aware of this. The Marketable Record Title Act, in short, is an archaic statute, in my opinion, but it does act to potentially have the declaration of covenants in an HOA expire if they're not preserved with certain procedures within 30 years of their original recording date. And more, we're seeing a lot more HOAs covenants that were drafted in the 80s that are coming close to the 30-year mark. And there's a very simple process put in by Florida statutes to preserve these documents by board action alone. And we've put together a little bit of a legal morsel to kind of make people more aware of that because we've had communities that have come to us for representation, HOA communities that have come to us, and they had not been notified in the past. And so a few of them had expired. And so we had to go through a much more tedious and costly process to reinstate them as opposed to just preserving them. So that's something else. That's all at kbrlegal.com. And that has our seminar information as well. And then to reach us by phone, you have 800-974-0680 is the main number. You can reach either Pompano or Palm Beach Gardens office from there. If you want to reach Pompano directly, 954-928-0680. Palm Beach Gardens is 561-241-4462.
You know, you come here every month for an hour, educate people. So I want to spend like the last 5 minutes. I want you to talk about your firm. I want you to tell people why, because there's people out there. I don't know how they can go without representation with a firm like with all the laws are changing.
They're running a business, like we said earlier.
Exactly.
You're running a corporation. You have your experts. You have your management team, perhaps. You certainly have your insurance agent. You have your accountant. I hope all these things in place. Have your corporate counsel. Have a line item in your budget to address your legal needs. Because this is not personal dollars. This is the corporation's money. And you sit at the table with the fiduciary duty to ensure the smooth operation of this community. And part of that is reaching out to legal counsel when there are potential legal issues. Don't sign a contract unless you have your lawyer look at it. I mean, I personally, I think doesn't matter the dollar amount, but certainly anything above $5,000, $10,000, certainly $50,000, $100,000 or more, reach out to your lawyer. I mean, if it's us, then
The
I
contracts are a big part of.
Well, sure, and if it's us, well, we're comfortable giving you a fair estimate as to what it's going to run. But I'm saying if you're going to spend $100,000 or more on a contract, you should be able to get it reviewed and have things put in place for another $1,500, maybe $2,000 on the high end if there's a little negotiation.
But you also shouldn't be afraid to do that.
Which you should not. Correct. That's pennies on the dollar. Especially if that old cliche, "Pay me now or pay me more later," it really is true when it comes to the contracts.
Sometimes I think people should swallow their pride a little bit. I've seen people who ran a big company. They think they could run an association, and it's so much different.
And I bet you when they ran their big company, they had legal counsel.
I bet they did too.
Well, those would be more inclined. Where you have people that didn't run big companies and did not have businesses that they were involved in that are now in a position of running these big companies, that they definitely need more help, and they should seek it.
Don't be afraid to ask. It's okay. It's not.
Well, really, just when you create your budgets, which you do every year, you're supposed to create what reasonable expenses. Have a realistic number for legal in a line item, and then you work that through now. And then each year you may have to you adjust it up or down depending, like you would any other line item. But I think that's where this way you're going to spend some money on when you have legal needs and you're in place.
And your firm's not a boutique, okay? This is all you do.
This is what they
This is all you do 24/7.
It is our concentration. We're very, very good at what we do. We're not a nickel and dime operation either. We get with our clients. We look to have long-term relationships. And if you're interested in having experienced counsel and working with us, having us accessible and responsive.
Right. It's important to note the firm's
Give
been
us a call.
continuously providing these services since 1992.
A long time.
It's a long time. Hey, guys, thanks so much for coming. We love
Thank you.
guys.
We'll see y'all next month.
First
Yes. Thanks,
Monday
guys.
of the month, we will be back. Thanks again.
Thank you.
Thanks for tuning in today to the Ask the Expert show with Steve O and Rene. Tune in every Friday from 4 to 5 p.m. while some of the top local experts in their field from Broward and Palm Beach counties educate you in the areas of law, health, financial, and home improvement. You can also call our offices at 888-574-6999 to become an expert on our show. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily